Good afternoon, everyone. My name is Whitney O'Reilly. I help run the Wealth Preservation Department here at Cohen Seglias. I have been an estate attorney for almost a decade now. And today, during this quick lunch and learn, we're going to learn a little bit about everything you need to know about beneficiary designations. Let me move my screen a little. I just want to make sure you guys can see. There's a question and a chat box. I will do my best if I see a question or I see something in the chat box to make sure I either incorporate it in what we talk about today, or if I don't get to it, I'll email you afterwards. I'll get a list of those questions. So I know we only have a little bit of time, and I see a lot of attendees. So let's get started. Everything we need to know about beneficiary designations. Again, like I said, I have been an estate attorney for about a decade now, but what does that really mean? So what that means is I do estate planning for clients. I draft your will or revocable trust, your power of attorney documents, your living will. I help you with business succession planning or trust administration. At the same time, after a loved one passes away, I help complete the probate or non-probate process, file state and federal death tax returns, and administer trust. So that's sort of big picture what I do. Certainly work with businesses as well on business formations. That sort of adds us into what we're talking about today, which is beneficiary designations and why they're so important. But it's really important for us to all understand that we hold assets in lots of different ways. So as an estate attorney, this is something that I see on an ever constant basis is the wrong beneficiary designation, no beneficiary designation, and what that can mean for an estate administration. And in simple terms, what that can mean is more expense, more delay, and maybe things going to the wrong person or the wrong place. So we're going to talk about the different ways that assets transfer when you pass away. So you have a last will and testament, or maybe you have a revocable trust. Of course, for your retirement benefits, life insurance, you should have a beneficiary designation. But you can have beneficiary designations on other assets, or if, let's say, you have a revocable trust, there might even be a beneficiary designation to the revocable trust. But there's also joint tenancy. So owning real estate in certain ways can transfer just like a beneficiary designation. So I sort of want to talk to you a little bit about each of these types of vehicles for transferring things when you pass away, because they go with the beneficiary designations and your entire estate plan, which is if you have a last will and testament, or you have a revocable trust, or you have a beneficiary designation, and they don't work with each other, there can be a lot of problems, a lot of additional expense after you pass away. So I can give you a couple of examples of cases that I'm either working on right now or have worked on in the past. I've done hundreds, if not upwards to 1,000 estate administrations here in Pennsylvania and New Jersey. And what I find is someone has a revocable trust that avoids probate, but there's no beneficiary designation on some of their assets of the revocable trust, or they didn't retitle assets into the name of the revocable trust, and now we have to probate, which is the exact reason that we had the revocable trust to avoid that probate. Or right now I have a life insurance policy of about $1 million going to a minor beneficiary. Is that really what that person wanted, a minor beneficiary to receive those proceeds at 18 or 21? Probably not. Most of us want that money protected for a minor beneficiary for a longer amount of time. Or we've got the wrong beneficiary. I have an estate administration where somebody had put a sibling before they got married and had children of a beneficiary account, an IRA, and unfortunately, they never updated that policy. Now we have millions of dollars going to someone else. How do we make sure that that doesn't happen to you? Well, one, it's not going to happen to you because you're here on the call today. And the biggest takeaway I want you to get from these 30 minutes is go back, check your beneficiary designation. Make sure they say what we want them to say and they coordinate with your estate plan. If you have any questions about the beneficiary designations, primary beneficiaries, or contingent beneficiaries, reach out to your estate attorney so that they can help walk you through it. So first, we're going to talk about a last will and testament. So I've included this great fiduciary checklist. I give this to all of my executors, administrators when we get to an estate administration. That gives us sort of an overview of what happens when somebody passes away, whether non-probate or probate assets. So things transfer through your last will and testament, things that do not have a beneficiary designation or have a beneficiary designation of your estate. Sometimes we have life insurance policies designated to your estate. There could be benefits and consequences to doing this, but as part of your overall estate plan, it may be something we want to utilize. So after you pass away, anything you individually hold or anything that you hold that has a beneficiary designation of the estate has to go through something called the probate process. That's where we go to the probate orphans court here in Pennsylvania, surrogate court in New Jersey. Someone gets sworn in as either the executor or the administrator. They get something called a letters testamentary or a letters administration. And with that document, it's actually called a short certificate because it used to be on a short piece of paper. It is still in some states, not in all states. And with that short certificate, the assets that are in the individual name or something has a beneficiary designation of the estate is going to be able to be transferred into the estate. And then through either the last will and testament or the intestate law here in Pennsylvania, the law regarding intestacy of someone who passes away is known as Pennsylvania's Estate and Fiduciary Code. That's in Title 20 of our Pennsylvania Code. And that really guides what happens. It's a default if we don't have something like an estate plan in place, or if we have a specific issue that our estate plan didn't address. That's where we go to find those answers for state purposes and the Internal Revenue Code for federal purposes. So here, we've got a list. I'm not going to go through all of it because we only have 30 minutes, but this is a great checklist. We're going to have this video and the handouts on our website. I do a lunch and learn most months, so go check it out. Check out the ones I've done before. Check this one out again if you want to gather something for it. Look at this handout. If somebody's passed away, these are the things that need to happen. Big picture, we've got to gather the assets, pay off the expenses, file tax returns, and then get that money down to the beneficiaries. So that's your last will and testament, a little bit about probate and non-probate assets. And this is really important because you might think, why are we talking about a will? We should be talking about beneficiary designations. This is what I signed up for. What should my beneficiary designation be? And this is an important component. Right now, I have a last will and testament, and I have something called a descendant separate trust underneath my will for my minor children. I have a 14-year-old daughter, Patience. I have an 8-year-old son, Paolo. If something were to happen to my husband and I do not want my couple $1 million life insurance policy going outright to my children at 18. From the decades of experience that I have with people under a certain age receiving lump sum large payments, 99% of them, it's a very bad result. So we don't want that. So through my last will and testament, I have this minor's trust for my children. You might say, well, that's okay. Don't put a beneficiary designation on my life insurance then. It'll flow through this last will and testament and it'll go to my children in this trust. And the answer is what we really want to do is we want to name the specific trust as the beneficiary. So for my life insurance right now, I have the primary beneficiary as my husband. That may not always be the case. We sometimes have spousal trust that we want to accept these benefits. But for me, at least right now, my primary beneficiary is my husband, and the contingent beneficiary is the trust for my children that's going to say how they get distributions. It's going to put some adult in charge of giving those distributions, and it's going to add creditor protection. If they get into a car accident when they're 18 and kill someone, this asset is going to be, everything that's in this trust is going to be harder to access. If they get married at 22 and divorced at 24, none of these assets can be taken in that divorce. Or if one of my children is a spendthrift and wants to use all that money taking 15 friends to Mexico, at least I have a trustee in place to say, that's not how this money is supposed to be used. Why don't we pay off your college education? Why don't we pay for your master's degree? Let's get a down payment on your house. So that's the first beneficiary designation recommendation is if you have an estate plan with a last will and testament, you should probably have something like a minor's trust, whether you have minor children, someone with special needs, whether or not you have a spousal trust, or for lots of my wealthy clients, we have trust for family members' whole lifetimes for all the benefits that we just talked about. So we want to make sure our beneficiary designations match that. On top of that, we had very recent legislation called the Secure Act that actually just changed the rules on how retirement accounts work and what happens when a beneficiary receives them and how they have to take that money out. So some of these trusts that estate attorneys created before 2019 actually don't work quite the right way that we want them to work now. So it's important if you have an estate plan, if you have a trust under your will, and you have a beneficiary designation of a trust, that trust still works the way that we want it to work, because we want to get as much money out to your family members as tax advantaged as possible. So the next we're going to talk about, like I said, give this a look. It's a great sort of synopsis of the things that have to happen very generically. There's certainly well more than that steps in an estate administration, but just sort of a little guide to what happens when someone passes away. So now we're going to talk about the revocable trust and how that relates to beneficiary designations. So if you on this call, you have a revocable trust and say, I've got a revocable trust. I don't need beneficiary designations, do I? I've got this trust that does it. Well, you need a beneficiary designation, otherwise it still falls to your estate. If you have a revocable trust, you also probably have a will, called a pour-over will. It takes everything that's in your individual name that you either didn't rename into the revocable trust or forgot to put a beneficiary designation on, and it's going to pour it into your revocable trust. And so some people would say, well, that's good, so I guess I don't have anything to do. And the answer is no. Most of the reasons, and I shouldn't say most, there's many reasons that we would do a revocable trust. But one of the reasons we do a revocable trust is to avoid probate and probate fees and probate administration. So if we put things in your individual name, we still have to go through probate. So it didn't really make sense to do that revocable trust in the first place. So if you have a revocable trust, it's important to retitle your assets in the name of the revocable trust. And you might say, okay, well, why are we talking about beneficiary designations then? Well, retirement accounts during your lifetime cannot be renamed into the name of a revocable trust. You're going to need to put a beneficiary designation on those assets. So I'm talking about a 401k. I'm talking about an IRA. I'm talking about a 403b. I'm talking about a pension plan. You're going to need to put beneficiaries of either the revocable trust or maybe, like we talked about for the last will and testament, maybe a trust underneath that revocable trust is who should be either the primary or the contingent beneficiary. And this is a really big takeaway right here. It seems very commonsensical and straightforward, but I had a client literally earlier this week say, I thought you were only allowed to have one beneficiary on my retirement account. That is absolutely not correct, and that's not the way we want it. If you only have a primary beneficiary on your retirement account, on your life insurance, you need to go back and update that. You need a contingent beneficiary, or that asset will wind up going to your estate and either accessible to your creditors or accessible to probate fees, or more tax will be due on them if you don't have that beneficiary designation. So it is really important, whether you have a will or a revocable trust, we need to make sure we've got that primary contingent beneficiary, it's the right beneficiary, and it's still up to date with the passage of lots of legislation affecting things that have beneficiary designations, like retirement accounts and life insurance. Although you could have a beneficiary designation on other assets, like a bank account, like a death account, or a payable upon death account or something like that. So we've talked about the last will and testament. We've talked about the revocable trust and beneficiary designations. We've talked about that trust underneath the will or underneath that revocable trust. And so now we're going to sort of talk about big picture beneficiary designations. What should my beneficiary designation be? The beneficiary designation, this is a little bit hard. We've got a bunch of people on this webinar, and everybody could have somebody different as the beneficiary or some different mechanism as the beneficiary. And what I mean by that is, for me, my life insurance says the primary beneficiary is my spouse. The contingent beneficiary is the trust for my child. And then I have a trust underneath my last will and testament that says the dispositive provisions of how my child can access those funds and what happens if my child has either already passed away or passed away during the term of that trust. So that's really important as well, because if we only have a primary beneficiary, or even if we have a contingent beneficiary of just someone's individual name and they pass away, what now happens? So for example, this happens many times in my estate administration, somebody has passed away, they're the primary beneficiary, and they've passed away, and there's no contingent beneficiary. So where does this asset go? Well, for example, I have a case right now. I have a Wells Fargo, a special kind of IRA, and because there was no beneficiary designation, according to this specific kind of retirement account, Wells Fargo has dictated in the policy that it will go to the spouse if the spouse is living, the children if the spouse is not living, and if there are no children, to the estate. So one, we've got to determine whether or not there's spouse, then we've got to determine whether or not there's children, and in this case, there isn't either of those. So it's going to fall to the estate. All the tax on that retirement account is going to be due upfront at once. So they're going to lose about 40% of it, this beneficiary, and they're going to receive the remainder. Whereas if that beneficiary designation was updated, they'd be able to take required minimum distributions. It used to be based on your life expectancy, but these new pieces of legislation, and I've done some webinars on these, so feel free to go back and look at it, but they've changed the rules of how you can stretch that IRA. You used to be able to stretch it for your entire lifetime. Now you can only stretch it out, depending on who you are, for maybe a maximum of 10 years. Spouses, minor children, someone who has special needs, and sometimes a brother or a sister can still get that lifetime payout, which is really important because it means more can grow tax-free and less is taxable each time it comes out, that's forced to come out. So it just means more money in the long term. So really important. One, what should my beneficiary be? Well, I'm not sure for your particular situation, but there should be a primary beneficiary and there should be a contingent beneficiary. And even if you have your children named, you might want to consider updating that to my children in persterpital shares. So persterpes, I love to say this word because I took about 8 years of Latin, and I wasn't actually sure what it taught me in life, but thankfully I became a lawyer, and we still use Latin-y like words like persterpes, which means by the bloodline or by the branch. That can be really important. So if one of your children passes away before you, you're saying you want their individual share to go down to their children, and if they don't have children, up and over to your other children. So it's a mechanism in place so that even if you don't go back and update your beneficiary designations, which again, this sounds very simple, but I have an estate administration right now where we had the beneficiary designation forms, we had all the paperwork, but the person got very sick very quickly. That paperwork got pushed onto another desk, and all of a sudden there's no beneficiary designation. We're going to lose 40% of this asset right away, many millions of dollars lost, all because we didn't follow through with that. So it's very easy to forget to do it, forget to update it. So as many mechanisms as we can have in place so that even if somebody passes away, if we've got that persterpital language, it will automatically go to the next heirs. So very important caveat one, Make sure you've got a beneficiary designation. If it's a trust, make sure that trust is the right trust and the right price now in 2020 or moving into 2021. And if we've got a beneficiary of, let's say, just your children, we might think about updating it to have a mechanism in place so that even if you forget to update those beneficiary designations and someone passes away, it still goes to where you want it to go. So what happens if you don't have a beneficiary designation? Of course, we already talked about this. It depends on the institutional policy. It often reverts back to your estate. So you want to make sure that you do have an estate plan in place. Otherwise, the intestate laws of Pennsylvania come into play, and that will tell us where those assets go. Some interesting caveats are divorce. Unfortunately, this happens all too frequently in my profession, where we do estate planning documents for clients, and then they get divorced. If you get divorced, please remember to update your beneficiary designation. There is a caveat underneath the Pennsylvania Estates and Fiduciary Code. I believe it's 6,111, I believe. But it says if somebody is divorced and we have a divorce decree or we're at a certain point in the divorce, we'll act as if that person was predeceased, unless there's reasons to keep it the way that it was, like it was the intention of the parties to keep this life insurance policy. It will act as if that person is predeceased. But that's where that contingent beneficiary comes into play, and not all things are covered by this law. So not all assets that have a beneficiary designation might honor the PEF Pennsylvania intestate law. And the biggest takeaway regarding after you make your beneficiary designations is you've really got to follow up. I can't tell you how many times I've litigated or had problems with a client who has a beneficiary designation, knows it's a beneficiary designation, then they pass away and it's not. Or it's an old trust that nobody can find and we don't know what it is. What do we do? Where does that asset go now? If we have these things that happen, there's me. I come into play. I can take care of everything, but I'm going to charge more money, and it's going to cause family problems. If we give an asset to someone else instead of your child, are they going to give it back to your child? Everything over the last decade, I have seen that happen very infrequently, where somebody gets an asset and maybe they shouldn't have, and they kind of know, and they're willing to give it to the person that they think the person who passed away really wanted it to go to. That doesn't actually happen frequently. So make sure you follow up, get a copy of that beneficiary designation, and put it with your estate plan. That's really important. That way, one, when you're not here anymore, somebody can see that beneficiary designation, but we can make sure that we either show it to your estate attorney or you've got it in place that says it is the way that we want it to be. So now we're going to talk about joint tenancy. We've talked about things passing through your estate, passing through a revocable trust, how that beneficiary designation works with your last will and testament revocable trust. And then we've got joint tenancy that says, well, it's not necessarily a beneficiary designation, but it kind of is because it does something automatically by law. And so for an example would be my husband and I owning our home together. He and I own our home by tenants by the entirety. So that is a special designation that's only allowed for people who are married here in Pennsylvania, and it gives us some super uber creditor protection. So if you are married, this is a great nugget of gold outside of beneficiary designations. But if your deed does not say, I own this as husband and wife by tenancy of the entirety or tenants of the entirety, then we might want to update it, because even though it has joint with survivorship provisions, as in if I pass away, it all automatically goes to my husband passes away, it automatically goes to me, just like a beneficiary designation. But during our lifetime, it gives us uber creditor protection, which is really important. Then we get to rights of survivorship. Basically, if we have a joint tenancy with right of survivorship, my sister and I own a piece of property together. If we own it joints with right of survivorship, when I pass away, automatically by law, it would go to her. But here's an example of why it's really important to see your estate plan as a whole, those beneficiary designations, how you hold your assets. Because if I own a piece of real estate and it goes to my sister when I pass away, but I have a last will and testament that says my estate will pay the tax, but the piece of property she and I own is a $10 million farm, and I only have $1 million worth of assets in my estate. We now have a problem of someone else paying the tax on something someone different is getting. So that is a really important component of beneficiary designations. We need to make sure the tax clause in your last will and testament, revocable trust, or the default laws under Pennsylvania's estate and fiduciary code makes it so the right people are paying the tax that you want them to be paying. And then, of course, you could own something as a joint tenant, but as tenants in common. And so what happens there is when you pass away, your undivided 50% interest is going to transfer through your estate, and we're going to have to probate your estate and either have it pass through a last will and testament, pour over will into a revocable trust, or the intestate law in order to get it out to the beneficiaries. So again, this is really important it's beneficiary designations, but beneficiary designations work in tandem with your estate plan, whether it's your last will and testament and that tax clause, or it's your revocable trust and a piece of joint real estate. And again, I see these kind of things all the time where we own a piece of property with somebody else and we don't account for that in our estate, as in someone else is going to pay the tax on somebody else's assets. So we don't want that to happen. So here I've just got a picture of your estate plan. Obviously, we're talking about beneficiary designations, but this works in tandem with your estate plan. A comprehensive estate plan includes a last will and testament or a revocable trust. I'm not sure if I've done a webinar recently on the differences between a will and revocable trust, but I'll do that again sometime soon. It's a question people ask all the time, and my answer is ever changed. And depending on the state that you and I are working on, the answer may change pretty dramatically as well. It'll include a financial power of attorney, a medical power of attorney, and living will, also called an advance directive. These are the kind of things that we need during your lifetime, especially in a time like this where we're in the midst of COVID-19 and a pandemic. If for some reason I got COVID-19 and was on a ventilator, who's going to take care of my financial and medical affairs? What do I really want at the very end of the very end? I need these documents in place ahead of time, because if I have a ventilator and I'm incapable of communicating, I want my wishes to be carried out. And then again, we may have various kinds of trust. We talk too much about the difference between an irrevocable trust and a revocable trust. But an irrevocable trust basically means it can't be fixed. Once you do it, once you stick an asset in it, it stays there forever and there's nothing else you can do about it. A revocable trust you can update from time to time. We'll do a webinar series on that. I'm sure I've done one of those in the past. And so we're coming just about, we only have a couple of minutes left to the end of this quick lunch and learn regarding everything you need to know about beneficiary designations. Hopefully you took from this webinar, it's really important to check those beneficiary designations. Make sure we've got a primary beneficiary. Make sure we've got a contingent beneficiary. If we have minor children, make sure we've got a trust in place, and it's the most up-to-date trust for today, since we've got lots of legislative changes. Let's make sure your estate plan coordinates with those beneficiary designations, so we're paying the least amount of tax possible and the asset is going where we actually want it to go. So for all of the people on this lunch and learn that know I love trivia questions and I love to play games when I do CLEs or large lectures, this helps keep us involved and think about a little bit about what we talked about. So I'm going to ask you all a trivia question. The first person who responds, I'm going to say let's put it in the chat, but if I see it in the question box, that's okay. The first person who gets the correct answer is going to get an Amazon gift card for $50. So let's see if the things that we talked about over the last 30 minutes are still there in the back of our brains, and let's see if we know the answer to this. So the trivia question is, and my screen is sort of in the way, you can all read it at the same time too, but if I have a beneficiary designation of my son, Paolo, but my will says everything goes to my wife, Whitney, who inherits that asset? Let's see, I don't have anyone who's answered yet. Let me keep looking. And as we get to the end of this, it is 12:30. I'm just going to ask if anyone has any questions. If there's something I can quickly answer, I certainly will. Any of the questions that I've seen throughout this in the chat, I've certainly tried to incorporate in this Lunch and Learn. And again, I just want to thank you very, very much for, and here, let me expand this. See if anybody's got the right answer. Okay. Wow, we've got a lot of people answering and a lot of people saying it one way or another way. So this is important to know. If I put beneficiary designation of my retirement account, let's say my 401k that I hold here at Cohen Seglias, the law firm that I work for, I put that beneficiary on as my son. I'm not sure why, I did it that way. I thought somebody told me to do that. And I said everything else goes to my wife, Whitney. Where are those assets going to go? The assets are going to go to my son. But what if I have a tax clause in that last will and testament that says everything's paid by the estate? Does that mean my wife, Whitney, is going to pay the tax on the asset that's going to my son, Paolo? What if it's a second marriage, a third marriage? What if my child was an adult when they got married? Now we have somebody else paying a tax on somebody else's assets. Again, we never want something like that to happen. And in the decade that I've been practicing, I can't say this enough, beneficiary designations is one of those things that 1 every 5 estates I have a problem, and 1 out of every 10 have a huge problem. And it's a pretty simple fix, which is go back, check those beneficiary designations, check in with me, check in with your estate attorney, and just make sure that they say what you want them to say. Again, if anyone has any questions, I don't know why, but sometimes I can't see. We're all learning a little bit about technology in this COVID-19 world, whether it's by webinar or Microsoft Groups or Zoom. We're certainly learning how to do more and more things remotely. But if there's any question that you have that I didn't get to, my contact information is here. Like I said, we're going to post this video. We're going to post a handout of the slides that you can look back at. And of course, if you have any questions, whether you're my client or you're not my client, certainly feel free to reach out, and I'd be happy to walk you through the beneficiary designations that you have and make sure that it coordinates with your estate plan. Again, thank you all for joining me today. My name is Whitney O'Reilly. I help run our wealth preservation department here at Cohen Seglias, a large construction litigation firm here in Philadelphia. Although we have offices in many states, do a lot of business transactional work. I look forward to seeing you again, and have a great rest of your day.